The 1921 Immigration Quota Act, Part 2, Chaos at the Individual Level. This video is a continuation of the impact that the 1921 and some subsequent quota laws had on U.S. immigration, mostly from Southern and Eastern Europe. Part 1 covered changes in shipping and pressures on U.S. consulates and immigration stations, especially Ellis Island, during the early quota years. Here in Part 2, separate video, I concentrate on the law's impact on individuals seeking to come to the United States. Most successfully navigated the quota laws, but some arrived only to be deported as they were over quota. A little bit of methodology. Using the subscription service newspapers.com and searching for 1921 quota and other keywords, I found many newspaper articles, and I'm going to share a lot of them with you. I also used the free website at the Library of Congress chronicling historic American newspapers, and I'll put those addresses in your show notes. The document images mainly came from FamilySearch.org. Registration there is required, but it's free. So if you're starting genealogy, I would suggest strongly that you enroll there. It has some extensive databases. So let's look first at aliens trying to get into the United States and the quota laws. We'll look first at non-quota aliens. Not every alien entrance was counted towards the quota. Exempt classes included but were not limited to government officials and their families and employees, those in transit through the U.S., tourists or temporarily here for business or pleasure. So here is the manifest of the steamer Cedric. It is coming into New York on August 28th, 1921. Got 4 people with stamps on the left side that say in transit. If you look at it, they say their nationalities are Great Britain. And if we look at this further to the right, and I think this is the two-page manifest, they all indicate that they were born, at least 3 of them, in New Zealand or Australia. But they all were trying to get to New Zealand or Australia by going through the United States from England. So they originally and eventually ended up in England, and now they're going back perhaps to their homeland. One would hope the immigration officials at the entry stations would know the new law backwards and forwards, and one shouldn't see transit immigrants being held at the U.S. port. This is from the New York Times, August 30th, 1921, on Tuesday. And this ship, which is actually the Cedric, came in on Sunday. So it says that 3 cabin passengers, these were not third class. These were not the cheapest tickets. Instead, they paid some money for this, and I thought that there would be some special courtesies given to them. But 3 cabin passengers who arrived on Sunday were detained because they had been born in Australia, although they went to England as a child and lived there ever since. They didn't think they were Australian. The inspector of immigration said he could not let them land until he had consulted Washington. The passengers were detained until yesterday, so they were detained on the ship for 2 days, until yesterday afternoon when word was received to let them go as they intended to catch a liner at San Francisco for Sydney. So some other exempt classes, aliens who have resided continuously for at least 1 year, immediately preceding the time of their admission to the U.S. in a number of specific countries. Aliens under the age of 18 who are children of U.S. citizens, and these are from the actual act. Now, I happen to have in my collection of memorabilia a third-class rate brochure for the United States lines. And they're very careful to tell people which category they would be in and whether they can get into the United States and either under quotas or not. So this is in 1928. This is 7 years later. There was an extension of the 1921 law. There was a new law in 1924, and this is an amendment in 1928. So let's see if some additional changes were made. So it says the immigration law, you can see the Act of 1924 and amendments of 1928. These are non-immigrants. They're not charged to a quota. Foreign government officials, family attendants, servants, and employees. An alien coming temporarily as a tourist or for business or pleasure. Talked about those. An alien in continuous transit through the United States. An alien lawfully admitted to the U.S. from who later goes in transit from one part of the U.S. to another through a foreign contiguous territory. I guess that must be Canada or Mexico. An alien entitled to enter the U.S. solely to carry on trade under and in pursuance of the provisions of a present existing treaty of commerce and navigation. Then we have immigrants. Some of them were non-quota. This is from the 1921 Emergency Quota Act on the bottom, which you can go and actually read the act, that aliens returning from a temporary visit abroad, they were exempt from the quota. Aliens who were professional actors, artists, lecturers, singers, nurses, ministers of any religious denomination, professors for colleges or seminaries, aliens belonging to any recognized learned profession, or aliens employed as domestic servants. Notice nothing about their families, though, just them. Talk about that later. May, if otherwise admissible, be admitted notwithstanding the maximum number of aliens of the same nationality admissible in the same month or fiscal year, as the case may be, shall have entered the United States. Now, there's a proviso here that says, but aliens of the classes included in this who entered the U.S. before such maximum number shall have entered shall be counted in reckoning the percentage limits provided in this act. Now, no more than 20% of the yearly quota could come into the U.S. in any 1 month from these quota countries. But it looks like these exempt from quota people are not quite exempt because they were counted toward the quota. But then above the quota, once it was reached, they could then continue to be permitted into the country. I think that's what this means. So the brochure says non-quota immigrants, an immigrant who is the unmarried child under 21 years of age, or wife of a citizen of the U.S., or the husband of a citizen of the U.S., if married prior to June 1st, 1928. Resides therein at the time of filing of a petition. An immigrant previously lawfully admitted to the U.S. who is returning from a temporary visit abroad. An immigrant who continuously for at least 2 years immediately preceding the time of his applicant for admission to the U.S. has been and who seeks to enter the U.S. solely for the purpose of carrying on the vocation of minister of any religious denomination or professor of a college, academy, seminary, or university, and now we see this in writing, and his wife and unmarried children under 18 years of age, if accompanying or following to join them. That wasn't always the case about the family. An immigrant who is a bona fide student at least 15 years of age. An immigrant who is born in Canada, Mexico, Central America, South America, Caribbean, and his wife and unmarried children under 18 years of age, if accompanying or following to join him. And then specific laws about citizenship of women who married an alien, U.S. citizens. So here, a woman who was a citizen of the U.S. and who prior to September 22, 1922, lost her citizenship, which did happen, by reason of a marriage to an alien, but at the time of her application to come back to the U.S. for an immigration visa, is unmarried. Now, within quotas, there were professional immigrants, and the professional class, according to the Emergency Quota Act, is that in the enforcement of this act, preference shall be given so far as possible to the wives, parents, brothers, sisters, children under 18 years of age and fiancés, 1 of citizens of the U.S., 2 of aliens now in the U.S. who have applied for citizenship in the manner provided by law, or 3 of persons eligible to U.S. citizenship who served in the military and naval forces of the U.S. at any time between April 6, 1917 and November 11, 1918, both dates inclusive, and have been separated from such forces under honorable conditions. And then this is from the Daily Worker newspaper, July 17, 1924. I don't know if this pertains to the 1924 Act or the 1921 Act or both, but it's apparent that they now discriminated between immigrants. So these immigrants within quota regulations were given first preference ahead of all other applicants, up to 1/2 of each month's quota, and also immigrants who were skilled in agriculture and their dependent children under 16. But the original 1921 law reduced the number of agricultural workers, and farmers either introduced people from Mexico and Canada, or they started to mechanize the production of agriculture. And so here they decided that agricultural people, farmers, could get this preferential status. There were waiting lists at U.S. consulates for people trying to get into the U.S. because of the quota rules. People within the preferential category were moved up the list. Others might have to wait years to get a visa to come to this country, even waiting at a port of embarkment to move up on a continuously changing list. It's really hectic. So there was lots of articles about actors, artists, and singers that appear to be exempt from quota laws. Who decides who's an artist? So I thought this would be a cute subtopic here. And one of these people, Ivy Schilling, had a lot written on her manifest, and so I did some more research on it. She was a dancer. She arrived in August of 1922 in the steamer Aquitania. Australia was over quota. Talk about Australia, which would seem to be in the news all the time. She was a professional dancer. She had U.S. engagements she was going to, but she was held aboard ship waiting for entry decision and eventually cleared for landing. And we know why she was cleared, because there's a note on the manifest. So let me show you the paper trail. So here's the steamer Aquitania, and there's Ivy Schilling. There's a notation on the left. She's a dancer, born in Australia. Someone put down professional dancer above that. And we're going to talk about manifests. You can see on the left, some people were stamped in transit. And on the bottom, and I had to do a lot of graphics to try and bring out the very light printing here. It says Ivy Schilling, line 21, now presents, and I'll show you what I got out of that. It says later, Ivy Schilling, line 21, now presents contract engagement with George Chuse, 110 West 47th Street, New York City, manager for professional dancers, 30 weeks at a salary of $450 per week, beginning September 1922. I went on one website that tells you what a $22 is today, and $450 per week is equivalent to $8,415 a day. So she was a well-known professional dancer. She was actually a surfer in Australia. And this is signed George Chuse, March 13, 1921. And the official now says, being now satisfied of aliens' exemption under Quota Act, I admitted her. And there is an ad for one of the performances she had. A little bit of cheesecake there. She's very acrobatic, obviously. Unfortunately, she injured her leg while she was in the U.S. and never danced professionally after that. Now, when I saw this, actually, I tracked down on the internet more information about Ivy, and there's a whole essay about Ivy Schilling written by Heathcote Pursuit, in which I asked if I could use the advertisement he found in this talk, which he gave me. If you want to know more about her, there's the short, fabulous career of Ivy Schilling. Well, could anybody who said they were an artist, had any talent at all, get in? And then it comes to the Italian Five. The newspapers had a field day on this. So here, 5 of these individuals arrived in June of 1922 on the steamship America from Italy. They said they were artists. It didn't look right, so they were sent to special inquiry. And they admitted there they never acted on stage, but came to the United States to debut their skills. Well, that didn't sound right. So at the hearing, the Board of Special Inquiry asked the 5 for an acting demonstration, on which the group said that they were singers, not actors. It was all the same in Italy. The board, after hearing the group sing, decided they were acting and singing and voted to deport them. Actually, that's when their performance really started. So unless a person appeals the board's decision, there are no existing records other than the information on the special inquiry sheet filmed with the manifest. But the newspaper article apparently repeated comments from the board. They could have made up some of this stuff also. So New York Tribune, July 10th, 1922. The board suggested that on the deportation ship, that the 5 could practice singing deep in the bowels of the ship so they wouldn't disturb anybody, and, quote, added encouragingly that the ship was a slow boat. On the way to the deportation ship, some of them became agitated and one tore out locks of her hair. Another threatened to jump overboard from the launch. So they were returned to Ellis Island. They somehow picked up a lawyer for further court hearings, but eventually all were deported. I'll show you the paper trail. So here are the 5, probably related to each other. Ida and Giovanni are a married couple. The Miraglia, Giuseppe and Elisabetta, are brother and sister. You can see they all put down they were artists. They're all from Italy, and they're all deported. You can see SI on the left, and then stamped over it is deported. Here's the special inquiry. The start of the left side, showing you their names, where they are. 51 is the sheet number, and 15, 16 are the lines that Giuseppe and Elisabetta are on. And then all the way, this is the middle of the special inquiry. Shows that first column is for deported. And then on the right-hand side, we see the number of meals they spent at Ellis Island and something about their voyage. Now, if you look closely and interpreting this, you see the Colombo. That's a steamer. So on July 7th, they were scheduled to be deported on the Colombo, and apparently even almost reached the ship. So on 7/8, they were returned to Ellis Island. So they may have gone out on 7/8 to the ship, and then they were returned. And then if we look at this, we find out they were eventually deported on the steamer Europa on July 17th, 1922. And there the number of meals. So they spent much of June and July before they were sent back. Now, the follow-up legal matter is that they had argued that they should stay at Ellis Island until the next month's quota opened, but a judge ruled they had to go back to their original embarkment port and go through the logistics all again. We'll see this requirement later as well when we talk about Blanche Cooper. They also could have been deported for their perjured statements. Now, I checked, and 3 of them subsequently arrived on the steamer Betraya on November 1st, 1922. I wonder if the people at Ellis Island recognize these 3. You see that a name is crossed out. That name is Ida, so she didn't go on the manifest on the ship. And now, all of a sudden, they're housemaids and a farmer. Vincenza went to special inquiry, but they eventually did admit her as well. So much for the artists. And one of them became a citizen. Another category was students. So the newspapers emphasized these 2 Spanish college students. They arrived on the steamer Chicago in September of 1922. The Spanish quota was filled, but they were sent to special inquiry. Maybe people didn't believe them. They needed to be quizzed about what college you're going to, etc. Carmen was going to attend Vassar in Poughkeepsie, New York, and Candida to attend St. Catherine's in St. Paul, Minnesota. And here is the New York Tribune, October 2nd, 1922, headline: Sunny Spain sends 2 senoritas to American colleges. Obstacles of Ellis Island and September quota hurdled with help of smiles. Spanish quota, which allows only 183 to enter the country per month until the quota is expired, had long been exhausted for September. So here's the manifest for the 2. They happen to be on a sheet that only has 2 names. You can see the SI then stamped over it is admitted. They're relatively old for students, 27 years of age and 24. They do say that they are students there, and they are Spanish. Here is their special inquiry. The shows there, and then the reason is EX quota, exceeding the quota. But they are students, aren't they exempt? And I think they should have been. And you can see here that they were admitted. There is no meal shown there. It was pretty much pro forma, it looks like. Now here's a case where a professional comes in. He had been in the U.S. before, and he brings in his family, and they want to deport his family. And this was before families of professionals was part of the exempt group. In fact, this may have established the precedence. So Gittel and mother and son, Israel, 4 years old, Gottlieb, they arrived in 1921 on the steamer Providence. Their father was a rabbi already in the U.S. who had a congregation. They were all born in Palestine. The Palestine quota was exceeded, and the officials wanted to deport the pair. So and in fact, the ship name was there, and I think they actually had moved them toward the ship. So the rabbi sued the U.S. and stopped their deportation, went before a court, and the judge ruled that the wife and under 16 child was an exception to the 1921 Act and established that they could come in legally. And I'll show you the paper trail. This is from New York Tribune of March 5th, 1922. So here is a manifest. It may not be that readable for you. The second line, the person was deported. His name was Efren. He was a student. He was deported. And you'll find out that his visa had been expired. It was expired. He's from Palestine. And then on the bottom, we have the Gottliebs, Gittel and Israel. She's 24, and he's 4 years old. You can see that they put down Palestine. And here is the special inquiry. Here we see that EX quota, they're on the top 2 lines. In fact, if we go down here, we can see Ephraim Levenberg. And the reason he was deported, not only is an ex-quota Palestine as a student, but his visa was expired. That's the reason why. And if we go across here, find out in the first two lines on the top that the Gottliebs were released by court. But here, look, the steamer Roma is shown here, and they were returned to Ellis Island on January 18th. So they spent quite a bit of time in Ellis Island, December, January, and even part of February before this was all cleared up. They were admitted to the United States. Now, one of the problems with the quota that they did for efficiency, but it created real problems, was the difference between nationality versus birth. The quota's birth is based on birth country, not nationality. So the quota law decreed that where a person was born, rather than the nationality or citizenship, would determine the quota class. This created unforeseen problems for many immigrants. So, case number 1 of Nicola and Anna Emanuelidis. They argued that their assigned by quota birth country was not the actual birth country of record, and they sued. So here they are. They arrived in New York in November of 1921 aboard the steamer Acropolis. The newspaper article, the New York Herald, claims their home was on the island of Rhodes. That's not true. The government claimed that their birth area was in Other Asia. They lumped together a bunch of smaller countries and mostly Turkey, I think, and it was filled. The quota was filled. The immigrants argued that their birth location was under Italian military supervision at the time, and the Italian quota was still open. They shouldn't be in Other Asia. So they went to special inquiry and were going to be deported, but they sued the government. And after a court hearing in December of 1921, the court decided they would have to go back. And the paper trail confirms this, but it's not clear to me, and there's no follow-up newspaper article, but they stayed in the U.S. and became citizens. So there was some appeal or some change. Something happened. So this is from the New York Herald, December 17, 1921. Case of Nicola Emanuelidis and his wife, who were ordered deported by Judge A.N. Hand. At the conclusion of the hearing of their case yesterday, Emanuelidis, who at one time kept a restaurant at 317 West 41st Street, went abroad after selling out his business about 9 months ago, and returned to this country on November 14th aboard the steamship Acropolis, bringing with him his wife. And there's the Acropolis upside down, and there are the Emanuelidis. And it's interesting what they did here. You can see that 2-835930. That is a search for a certificate of arrival, which indicates that she was going through the citizenship procedure, and he actually became a citizen earlier than that. So let me blow up the column that says nationality. They put down initially protege Italian, meaning that they were under the care of the Italian government. Their race they put down as Greek, and some official put down Turkey on there. If you look at the place of birth in the manifest, they say that they were born in Nisirus. It's an island. We're going to talk about that. And they put down Italy, and an official, put down Turkey. So what's going on? Here is a map of the area. Where this island is where the red marker is. The island of Rhodes is to its lower right. It's not on Rhodes. The upper right is Turkey. The upper left is Greece. And to the west of Greece is Italy. So the Herald reports that the immigrant had been at his old home at Nisorius, which also can be spelled Nisorius, on the island of Rhodes, which is not true, which this government holds to be part of Other Asia, the quota of which has been filled. Emanuelides contended that the island where he was under military supervision of Italy, and therefore he is really in the province of Italy, whose quota has not yet been filled. Sure, there was lots of arguments like this. After World War I, there were all sorts of changes before as well. Judge Hand, after listening to the arguments made, decided that he and his wife will have to go back. That did not happen. However, they weren't deported, and this island is not on the island of Rhodes. The history of the island, according to Wikipedia, is that it was owned by the Ottomans from 1566 to 1911, when the Italo-Turkish War was fought. So when Nicola and Anna were born, it was part of Turkey. It was part of Turkey in 1910, when the country's quota statistics were formulated. But when they arrived in 1922, it was then part of Italy. It was finally, after World War II, annexed to Greece. So here's the manifest. And I guess this is a special inquiry, actually. It shows Nicola and Anna. And then it says here, we're in a hospital. Cause of detention released. No, it looks like no quota. Low quota. If we go all the way to the right here, it shows that they were landed. Spent a lot of time on Ellis Island in November and December. And one of the things that I tried to figure out was, well, I'll show you. In this case, it's landed. They weren't admitted, they were landed. Show you problems with that. I saw many cases of individuals being born in low quota assigned Australia or South Africa, whose on-paper nationality was Great Britain or Germany, two nationalities that the quota laws were designed to favor. So it created a paradox for some people. They really wanted these people, but they were born in the wrong country, it seemed. So husband is the Commissioner General of Immigration, put out an assessment in April of 1922 on the quota with suggestions for improvement. And he said if the Act of May 19th is to be amended, ensuring that the always very limited immigration of European origin from New Zealand, Australia, and South Africa shall not be prohibited. Not native Australians, but European origin Australians. So there was a certain amount of discrimination between people from a country as to who they wanted to come into the U.S. Whether this actually happened, I don't know. So let's look at two separate people from South Africa, for instance. So here's Margarita Rung. She was born in Cape Town, South Africa. She had German citizenship. Parents were Germans. And when she was in Hamburg, Germany, she showed the Hamburg American Council her papers and wanted to go to the U.S., and the visa was issued. She arrived in September of 1922 in the SS Kropessa at Ellis Island. African quota was filled for 1922. They said, "You're an African. You're not a German." She was sent to special inquiry. They voted to deport her, and she appealed to Washington, and she was deported. This is from her. This is a quote. "It puzzles me to think that Americans should have such a cruel law. I am in no sense an African. My father went to South America," that's probably a typo, "from Germany and never relinquished his German citizenship. It is true that I was born there and remained there until I was 21, that I was not particular about preserving my citizenship papers, showing that I am, and always have been, a German subject. I showed these papers to Ellis Island officials to no avail. I showed them to the American consulate before I came here, and he visaed my passport with the assurance that the quota law would not stop me. I might have gone to the Fiji Islands with less risk of barbarous treatment. New York Tribune, October 16th, 1922. And there she is. You can see she was deported. Place of birth, South Africa, Cape Town. And here she is. She's on line 4. I'm showing you a bunch of things here. Likely public charge and causes of detention. CL is a contract laborer. A laborer could not have a contract before they came here. They would have been deported. We have people who are a PD, physical debility, on the bottom, or maybe even PhD, which is still physical disability. I'll put in the show notes an essay which interprets these abbreviations on the Board of Special Inquiry lists for the reason they were detained. In any case, if we look across here for her, you can see actions of the board. She's on line 4. Shows that they voted to deport her. 10-2. And then on 10-14, you see the steamship Orbiter, and she was deported. She was deported. Compare that to Phyllis Hosking. She was born in South Africa of English parents. She lived nearly all her life in England. She arrived in New York on the SS Orbiter in September of 1922. Again, the quota of Africa was already filled. She went to special inquiry. But this case, Senator Edge, a U.S. Senator of New Jersey, took an active interest on her case, and he had her paroled to her father. I don't know why there was a date of October 1st, but it was paroled to her father. And if we look at the manifest, we see on the 4th line, her father, Mr. H. Hoskin, was in Bayonne, New Jersey. That's who she was going to visit. So here is the manifest. We go down to line 6. We see an SI on the left column for Phyllis Kathleen Hosking. Says she's English. Her nationality is English. No one changed that as opposed to Margarita. Blow that up. In terms of the place of birth, you can see that she was born in South Africa. And then when we look at the special inquiry, she is down there, Phyllis Hosking, QE, and then we look there and she was now paroled. So here we have actions of the board. Some people were deported, were asked to be deported. Of those 3 there in the left column, 1 was landed, 2 were paroled. And then the 3rd column, which is masked here, were people who were admitted. I could not find a really clear explanation, definition for landed, paroled, etc. So it pays to know somebody, right? Now, one of the worst things that could happen is a family could be separated because of the quota laws. I documented several families whose minor children, even babies born aboard the steamer, had different and over-quota birth countries. In those cases, they went before special inquiry and were usually admitted to the U.S. I didn't find any exceptions. Remember, husband, our commissioner, with his assessment about ways of improving the quota in 1922, said if the act is to be amended, he would suggest giving legal authority through administrative discretion or otherwise to the end that immediate families shall not be separated because children and parents happen to be born in different countries. Well, I don't know whether that was always the case. I don't think they did anything about that. Here is Perth Amboy Evening News, February 21st, 1922, in which they're quoting from husband. It says that stories of families separated by the immigration quota law are largely exaggeration. Largely exaggeration, that means it does happen. Was explained to the writer by Mr. W. W. Husbands, Commissioner General of Immigration today. It has been the policy of the department, said Mr. Husband, not to separate families. In no case has a small child been sent back to his native country without his parent or guardian, and even larger children who are debarred are not allowed to go back without a relative or some substitute guardian authorized by the family. Now, if you look at the last statement, they did separate families. Show you the case of Walter Davis. He was born in Egypt from a military family assigned there. He left Egypt with his parents, they were British, at the age of 5. He never went back. He served as an officer in the British Royal Flying Corps. When he immigrated to the U.S. in September of 1921, as an adult on the steamer Berengaria with his wife and son, both born in England, and under quota that was really open, because of his Egyptian birthplace, he was evaluated with a low quota numbers for Africa, which was full at the time. And so they wanted to deport him. Deportation was in his future, but the U.S. would accept the other members of his family, quite willing to separate families. He appealed to Washington, and his process included, according to the New York Tribune of January 1922, "If I had been born in a stable, would I be a horse?" And here's his manifest. The family is shown there. Actually, he became a citizen, and it's interesting what they did with his nationality. He had put down his nationality was Great Britain, and they had crossed that out and put down Africa, and then started Great Britain again for his family. And you can see where he was born. He was born in Cairo. And now we're at the special inquiry. Somebody was hospitalized. They put down likely public charge for the family. And then QE, quota exceeded for Walter, number 1. And then on the left side, we see that the actions of the board, deported, 9/23, they decided they would deport him, but then he was landed on 10/7. And they spent a lot of time there, December, October. Let me show you the case of Lois, because she's the mother of Pierre Dupont. I'll get it right. Lois Dupont, teacher of French in the Daytona High School, was stopped because her the manifest shows 17-year-old son, Pierre, was born in the Seychelles Islands, off the coast of Africa, and as a native African was not admissible, which is interesting because the Seychelles was a colony of Britain. It could have been British. And what I don't understand is that Mrs. Dupont was born on the island off the coast of Africa called Reunion, which was Department of France. So that really confused me, but that's not what this is about. They were going to deport Pierre because the African quota was filled. However, James J. Davis, Secretary of Labor, I found out, according to this newspaper article, who visited the island yesterday when this was happening, conferred with Robert Todd, Immigration Commissioner on Ellis Island, on the interpretation of the rule that later in the day caused Mrs. Dupont to be detained, or at least her family. The Secretary said, "I do not believe the makers of the quota law ever intended that it be interpreted so literally as to present our benevolent Uncle Sam in the light of stealing a mother's child away from her upon a bare technicality. I agree with Commissioner Todd, who has always been opposed to such practices. We are preparing to get a ruling on this matter, so there will be no more stealing of children under the literal interpretation of the law." I don't know whether they ever did this. You know, when you see words like ing words, preparing, They may or may not have ever done that. And in fact, in the Perth Amboy News that I've been quoting from with husband's interview, husband says that immigrants in excess of the quota limitations that were admitted have been temporarily admitted in order to prevent undue hardship, whatever that means temporarily. They are placed under bond to return to their own countries if Congress does not pass legislation allowing them to stay permanently. Bond must be a signature bond. There's no indication on the manifest of these bonds. It would be almost impossible to gather up these 1,743 immigrants from all parts of the country to deport them, these people with undue hardship entries. It is hoped that Congress will legislate to settle satisfactorily these comparatively few cases which the quota law did not anticipate. So it looks to me like he's even given permission to these people who are temporarily admitted to just stay here because they're not going to be deported. So it's really kind of a strange situation. But what about a situation where one of a family, an adult, was born in a country whose monthly yearly quota was filled? Although Commissioner Husband indicated their policy was not to break up the family, I'm going to show you a case of a family that they broke up, the Coopers. So Blanche, husband Albert, and 2-year-old Gladys arrived on the steamer Saxonia in August of 1922. Blanche was born in Australia, whose U.S. quota was filled. Albert and Gladys were born in England and under quota. In fact, Blanche spent most of her life in Australia before immigrating to the U.S. The family spent about 2 weeks at Ellis Island. The Special Inquiry Board moved to deport Blanche. Blanche was deported on August 5th in spite of appeals from friends and welfare organizations to Washington, D.C. The baby and husband stayed at her mother's place in Medina, New York. So she left, almost immediately got on a boat, and came back. Blanche returned to the U.S. on the steamer Saxonia on September 2nd, 1922. There's a quote in the newspaper from her to the Australian press. But this is a quote from the Washington Herald. Sydney, August 27th, is continued Australian criticism of the immigration quota system and conditions at Ellis Island. The Sydney Sun says, quote, "America is a wealthy, enterprising nation, and it is a pity she doesn't keep her front doorstep clean. We're continually hearing from Australian visitors of the filthy conditions at Ellis Island." Mrs. Blanche Cooper, an Australian woman, was refused entrance owing to the Australian quota being reached and was compelled to remain on the island a fortnight, associated with the scum of the earth, sleep on dirty blankets with no pillow, and with no facilities for washing her clothes. Ellis Island is the island of tears and the island of joy. So here is a manifest. There are the Coopers. I'm not sure who some of these other Coopers are. We have Albert, Blanche, and Gladys. You can see that their place of birth is mostly England, but Blanche is Australia. They consider the nationality all British. And then a Special Inquiry has the three of them up on the top. Again, they threw in this likely public charge. And then the EQ designation, if we go all the way to the right, we see that those two were landed, but she was shipped out on the Mauritania. And then I found where she came back. She came back the next month on the steamer Saxonia. There's Blanche, a housewife. Eventually became apparently a citizen of the United States. So I hope you enjoyed this two-part series. First part describes in some detail the impact on shipping of this Immigration Quota Act. This was part 2, chaos at the individual level. So this is another of my JDW talks. I have YouTube talks on genealogy topics, census resources, Ellis Island immigration and naturalization, natural history topics, virtual birding field trips, birding optics, California birds, and interesting to me, novelty zithers, and biology songs. So I hope you enjoyed this series and gained information about an important part when the United States actually changed and the immigration laws substantially against people from Southern and Eastern Europe. Bye-bye.